Hey, so there is other video on how to handle the desire to try to go back to work part-time, at least part-time, while you have a pending claim. I think the other video was when someone was on initial, but what about the situation where someone is, let's say you were denied after an ALJ hearing, you have appealed to the appeals council, you are awaiting appeals council decision of whether to review or not. And you want to go back to work or try maybe something remote, something within your abilities, maybe part-time, late hours, flexible, whatever. Um, can you do that? It's really the same. It's really the same analysis. If people do have to go back to work sometimes in whatever form they can, even if they can't do full-time work at any occupation, they will often, if they can, because we're not useless necessarily, seek to go back to some kind of work. So as always, you want to have an analysis of the kind of job you're going to get, and you want to make sure it does not entail duties that you can't do based on your disability as per your case. If like if you indicated that you have a very bad back, you wouldn't be doing something that requires lifting. You might not be doing something that requires a lot of time on your feet if walking and standing hurts your back. Likewise, oftentimes sitting is something that can be very painful to a back. So maybe you wouldn't be doing a sitting job. And going back to the part-time nature, if 8 hours a day of anything hurts you, I wouldn't suggest you go get an 8-hour a day, 3-day a week job. Only because if the pain's going to get to you anyway, the job is probably going to fail. But also the fact that you do put in full 8-hour days might give fodder to the idea of someone who's looking at it later. And that wouldn't be the appeals council because they're looking at what happened before. But if it gets remanded back or if you apply for something again later, that's when it would be coming up, right? Because it would be your past work. So, if an 8-hour day is generally not doable by you, you might want to avoid that when you do part-time work. You might want to try to do 3, 4, or 5-hour shifts, 3 days a week. The amount of dollars that you can technically earn without barring disability based on the amount is $14.70 in 2023. That's SGA, substantial gainful activity, even if it's part-time, if you're earning that much. However, cautionary tale, it's really wise not to flirt with that $14.70. I wouldn't even come within a few $100s of it. I would stay clear of it. Keep that part-time work, that part-time. All right. If you're a higher income per hour person based on skills, that might mean much fewer hours. That can be a little difficult, actually, for higher paid workers to actually be able to get a job where you'd only have to do such few hours. Lower paid work, it's not so difficult because you can work more hours and stay under that amount. But again, another optic would be the amount of hours you're working. If it's part-time and you go, well, it's 35 hours a week, it's part-time, that's not going to be optically very, very smart. And honestly, it would kind of give almost anybody, including myself, the perception that you could do that another 2.5 hours and make it full-time. Or some people consider 35 hours a week full-time. But the same can be true for 25 hours. I'm not sure it's true for 20 hours, but I always recommend 15 or less. So there's all these different ceilings, if you will, of what can be a smarter way to go back to work so that you're not giving false leads accidentally on more abilities than you have. Okay, so give it a shot. I hope this helps. Keep under the SGA limit and keep those hours low and keep the duties that you are doing not in conflict with what your impairments are. And again, if you're on appeal to the appeals council, consider the impairments that you had before, and of course, any new ones, but the things that you said in your function report that you can't do, I would take a look at that. I would consider, what that says. What did you say at your hearing? Because, if you win at appeals council, you're most likely going back to the same judge. So keep that all in mind when you start back to work, which you might not have been doing when you went before the judge before, and he still denied you. So you want to keep those things in mind when you pick and choose what you're going to be doing. Okay, to the extent you can. And of course, don't do anything that's going to damage your body further or your mind. Try to be safe, but it's true that oftentimes we do have to work, or else we're going to go financially down the tubes if we can't, find other more creative ways to sustain ourselves in the meantime. Okay, I hope that helps.